Civil litigation is how the law resolves disputes between private parties, individuals, companies, or organizations. It's about compensation, not punishment. In this lesson, you will learn 20 key terms that describe the entire civil process, how cases begin, proceed, and conclude, from complaint to judgment and settlement. These are the words that every lawyer uses daily in civil practice. By the end, you'll understand how to describe legal proceedings confidently in English and explain each stage clearly to your clients. Legal English gives you the precision to discuss cases, negotiate settlements, and analyze judgments in any jurisdiction. Inside our legal English community, you'll practice real litigation scenarios, filing complaints, drafting motions, and discussing court strategy in English. We meet weekly with lawyers and students across the world. Join us today to strengthen your professional communication and speak the language of law fluently. A civil case is any legal dispute that doesn't involve a crime. Our example, the civil case involved a contract dispute between two companies. In civil law, one party claims harm or loss and seeks compensation or another legal remedy. The focus is on resolving disagreements, not punishment, but fairness and restitution. Civil cases cover everything from personal injury to property and employment claims. Understanding how civil cases differ from criminal ones is the first step toward mastering procedural law. A party is any person, company, or organization taking part in a legal action. Our example, both parties submitted their evidence to the court. In every case, there's a plaintiff, the one who sues, and a defendant, the one being sued. Parties present their claims, defenses, and evidence through lawyers or directly to the court. In legal writing, clarity about who the parties are prevents confusion, especially when there are multiple plaintiffs or corporate entities involved. The plaintiff is the person or organization that brings a civil case to court. Our example says, the plaintiff claimed damages for breach of contract. The plaintiff must prove their claim by presenting facts, documents, and legal arguments. In civil law, the standard is the preponderance of evidence, meaning more likely than not. Without the plaintiff, there's no case. They initiate the process, file the complaint, and carry the burden of proof. The defendant is the person or company being sued. Our example says, the defendant denied liability and filed a counterclaim. Defendants respond to complaints by admitting, denying, or challenging each allegation. They can also bring counterclaims if they believe the plaintiff caused them harm. The defendant's right to be heard and defend themselves is central to procedural fairness. In civil cases, a strong defense can reduce or eliminate liability, even without proving complete innocence. A complaint is the first document filed to begin a civil case. Our example, the complaint alleged breach of contract and negligence. It explains who the parties are, what happened, and what the remedy the plaintiff seeks, often damages or an injunction. The complaint sets the tone of the entire case. Lawyers must draft it carefully because every word becomes part of the court record. Once filed, it is served on the defendant, who must respond within the legal time limit. A summons formally notifies the defendant that a lawsuit has been filed. Our example states, the court issued a summons directing the defendant to appear. The summons explains the nature of the case, deadlines for response, and possible consequences of ignoring it. It ensures the defendant's right to due process. No one can be judged without notice. Proper service of the summons is essential. If done incorrectly, the case may be dismissed. For lawyers, managing service procedures correctly is a basic but critical part of litigation. A pleading is how each party tells their side of the story in writing. Our example, the defendant filed a pleading denying all allegations. Pleading includes complaints, answers, and counterclaims, each structured and supported by facts. They are not casual documents. They define the boundaries of the dispute and what the court will decide. Inaccurate or incomplete pleadings can weaken a case before it even begins. For lawyers, drafting pleadings requires both precision and persuasion, presenting facts clearly while shaping the legal narrative of the case. A motion moves the case forward, or sometimes ends it entirely. Our example, the lawyer filed a motion to dismiss the case. Motions can ask the court to strike evidence, postpone hearings, or decide parts of a case before trial. Each motion must explain the facts, cite legal authority, and request a specific remedy. Effective motions save clients time and money by resolving issues early. They are a key test of legal reasoning, written advocacy in its purest form. Jurisdiction defines the boundaries of judicial power. Our example, the court lacked jurisdiction because the dispute occurred abroad. Courts can only decide cases within their geographical or subject matter limits. Filing in the wrong jurisdiction wastes time and may lead to dismissal. Lawyers must determine whether the court has personal jurisdiction over the parties and subject matter jurisdiction over the dispute. In international or cross-border litigation, jurisdiction questions become even more complex, often determining where justice can truly be served. Evidence is what turns argument into proof. For example, the plaintiff presented documentary evidence to support her claim. In civil cases, evidence can include contracts, invoices, photos, or witness statements. The burden of proof lies with the plaintiff, who must show that their version of events is more likely than not true. Evidence must be relevant, reliable, and very important, lawfully obtained. Lawyers build their entire strategy around how to introduce, challenge, and interpret evidence because it's the bridge between facts and justice. Discovery is the truth-seeking stage of litigation. For example, discovery revealed key emails that changed the case. During discovery, each side requests documents, submits written questions, and interviews witnesses under oath. The goal is transparency, to prevent surprises at trial. Discovery often determines settlement value, as hidden evidence comes to light. Although time-consuming, it is where the strengths and weaknesses of every case are truly revealed. Effective discovery requires persistence, organization, and strategic thinking. A deposition is testimony given under oath before trial, outside the courtroom. For example, the witness's deposition was recorded for use at trial. Lawyers from both sides attend and ask questions, while a court reporter records every word. Depositions allow lawyers to test credibility, clarify facts, and preserve witness statements in case someone cannot appear later. They can expose inconsistencies or reveal hidden strengths in a case. For litigators, mastering depositions means mastering the art of questioning. An affidavit is written testimony sworn to be true. Our example, the witness submitted an affidavit confirming key details of the agreement. Affidavits are used when live testimony isn't possible. For example, in urgent hearings or procedural matters, they provide factual support in a clear, signed, and legally binding format. Lawyers must ensure every affidavit is truthful and based on first-hand knowledge, since false statements can lead to perjury. Affidavits combine efficiency with accountability, putting truth in writing, under oath. A hearing is a focused courtroom session to resolve a specific issue. Our example says, the judge scheduled a hearing to review the motion. Hearings can occur throughout the litigation process to set deadlines, discuss motions, or address procedural disputes. They may be short and informal or highly technical, depending on the topic. Even small hearings can change the direction of a case, so lawyers prepare as carefully as for trial. A hearing is where arguments meet authority, where written advocacy becomes spoken persuasion. An injunction is a powerful tool, a command from the court to act or refrain from acting. Our example says, the court issued an injunction preventing the company from using the trademark. Injunctions protect rights when money alone can't fix the harm, like stopping pollution or misuse of intellectual property. They can be temporary or permanent, and violating them can lead to contempt of court. Lawyers must prove urgency and irreparable harm to obtain one. An injunction transforms legal argument into immediate protection. A judgment is the final decision that ends the dispute. Our example, the court entered judgment in favor of the plaintiff. The judgment specifies who won, what damages are owed, or what obligations must be fulfilled. Once entered, it becomes legally enforceable. Judgments may include orders, injunctions, or monetary awards. For lawyers, the judgment represents both resolution and accountability, the moment when all arguments take written, binding form. Damages are how the law measures loss. For example, the jury awarded damages for breach of contract. There are different types. Compensatory damages reimburse actual loss. Punitive damages punish extreme misconduct. Calculating damages requires both legal and financial skill. Lawyers must connect each dollar claimed to evidence of harm. For clients, damages are not merely money. They are recognition that the system acknowledged their injury and restored fairness. A settlement is a peaceful ending to a legal conflict. Our example states, the parties reached a settlement after months of negotiation. Settlements save time, money, and uncertainty. They allow both sides to agree on terms, payment, apology, or future conduct, without needing a judge's decision. Lawyers draft settlement agreements carefully to ensure they are final, forcible, and fair. In civil litigation, most cases end in settlement, proving that the best resolution often lies outside the courtroom. Winning a case is one thing. Enforcement makes it real. For example, the plaintiff filed for enforcement after the defendant failed to pay damages. If a party refuses to comply with the judgment, the court can seize assets, garnish wages, or impose fines. Lawyers often guide clients through this final stage, ensuring that victory on paper becomes reality. Enforcement is the test of justice, proof that court orders carry real power. An appeal is the safeguard of fairness. For example, the defendant filed an appeal challenging the judgment. Appeals review legal errors, not the entire case again. Higher courts examine whether the law was properly applied and whether the trial was fair. Successful appeals can reverse judgments or order new trials. For lawyers, appellate advocacy is an art of precision, turning complex trial records into clear, persuasive legal reasoning. A civil case begins when a plaintiff files a complaint against a defendant, two parties seeking justice. The court issues a summons, and both sides exchange pleadings and motions. Once jurisdiction is confirmed, discovery and depositions reveal crucial evidence. At a hearing, the judge considers an affidavit and grants an injunction to prevent harm. Finally, the court issues its judgment, awarding damages to the plaintiff. But before enforcement, the parties reach a settlement, avoiding further costs. Still unsatisfied, the defendant files an appeal, seeking to overturn the ruling. This journey shows how civil litigation balances procedure, negotiation, and fairness, guiding disputes from conflict to resolution through the precise language of law. You have now learned 20 of the most important terms used in civil litigation, from complaint and motion to judgment and appeal. These words form the language every lawyer who resolves disputes needs to use. It'll help you negotiate settlements and defend client rights. But vocabulary becomes powerful only through practice. Inside our legal English community, you'll apply these terms through real practices, real exercises, mock hearings, and live discussions with other international professionals. Whether you're a student, paralegal, or practicing lawyer, mastering this language will sharpen your advocacy and open new professional doors. Join today and continue your legal English journey, one conversation at a time.